Good afternoon, everyone, and hello from me. I'm Joe Middleton, Chair of the HRLA, and it's my pleasure to chair this final panel of the day. Unfortunately, Yasmin Ahmed from Human Rights Watch is unable to join us, but we still have three fantastic speakers to entertain and inform you. Our first speaker is Caroline Cassin. Her career is a blend of legal expertise, human rights advocacy, and cultural heritage preservation, and as a legal advisor in both France and the UK, her focus on art law restitution, particularly in the context of artworks and cultural properties plundered during the Nazi era, reflects a deep commitment to justice and historical rectification. Her work is intertwined with her Jewish identity. Caroline is a member of the family of René Cassin, who was, of course, a preeminent figure in the 20th century human rights landscape and was the second president of the European Court of Human Rights, and also has a particular connection with the Universal Declaration that I think Caroline may mention. As a member of that family, Caroline has been proactive in keeping his legacy alive through events, talks, and family website. Caroline is also a much valued member of our executive committee. So Caroline, over to you.
Thank you. So today marks the 75th anniversary of the Universal Declaration of Human Rights. So thanks for inviting me. The primary architect was René Cassin, a French lawyer from our family, the Cassin family. Today, I want to share what I've learned from conversations, anecdotes, family footsteps in Bayonne, exploring French archives over the past 20 years about the first cousin of my husband's grandfather, René Samuel Cassin. René Samuel Cassin grew up in Bayonne, southwest France, within a Sephardic Orthodox family that was well known and respected. His family had a history of living in the Saint-Esprit ghetto, but had since become integrated into the wider society of Bayonne. The family owned Rachel Cottage, a property spanning 4 hectares, which was named after René's grandmother. This was where René spent his childhood. As René Samuel Cassin grew older, the simplicity of his childhood began to change. The discussions at home, which used to be about our family traditions, started to shift toward more serious topics like French politics and the increasing anti-Semitism in society. His grandfather, Léon's involvement with the Dreyfus affair became a frequent topic of conversation, influencing René's early understanding of these issues. René's mother, Gabrielle Dreyfus, played a crucial role in his life, ensuring that René's education was conducted at home, allowing the family and cousins to observe the Shabbat faithfully. René had several tutors who taught him not just academic subjects, but also values that were important to our family's faith and heritage. The principles of justice and equality, especially as exemplified in the teachings of Exodus, there shall be one law for the citizen and the stranger who dwells among you, had a significant impact on him. Further reinforced by the commandment of loving our neighbor as ourselves, advocating for one law that applies to all, irrespective of tribe, wealth, and power. At 13, for the first time, Cassin interned into the French Lycée of Nice. He was often at the top of his class. At 16, missing the philosophy registration, he ended up last minute in law at Aix-en-Provence University. He excelled in his studies, topic general competitions across all law faculties in France. The First World War abruptly interrupted René Cassin's academic pursuits. As a soldier, he suffered severe injuries from machine gun fire. He faced personal tragedy with the loss of his sister Felice and took on the responsibility of caring for her 4 children, whose father, Raoul Abram, died in the war. This experience heightened his awareness of the struggles faced by widows and orphans. He firmly believed that the individual should come before the state and that reparation was a right, not a favor. Cassin's role as a representative for French soldiers led him to the League of Nations. A significant moment occurred in 1933 when Goebbels made a declaration that Germany would treat its Jews as it saw fit. In 1941, Professor Cassin left for London with a sailor's bag to meet Raymond Aron on the Ettrick liner. There, he heard General de Gaulle's declaration, "I am France. Vous tombez à pic. You are at the right time. I need a lawyer." Driven by urgency in London's Hyde Park, Cassin quickly drafted the Churchill-de Gaulle Accord in just 30 hours. The signing of this document, while acknowledging the slight disturbance caused by Churchill's cigar, was a significant event in Cassin's life. After the war, the devastating news that our family had been deported to Auschwitz and the loss of our Rachel cottage spoliated further strengthened René Cassin's determination. Motivated by a desire for a world where human rights are respected, he was inspired maybe by the inclusive message from the Bayonne synagogue his grandfather had helped establish. "My house shall be called a house of prayer for all nations." Cassin was part of the 8 members committee. One evening, he drafted the articles of the Universal Declaration of Human Rights. He strongly advocated for the term universel. His dedication to the project led to the creation of this important document, which was adopted by the United Nations, December 1948. When he was awarded the Nobel Prize, he said, "Today, where there is no respect for human rights and freedom, there is no peace either. Every day, young people fall on the battlefields. Every day, prisoners are taken to prison and torture chambers. Peace, everyone must seize it every day." René Samuel Cassin, member of the government of Free France during the Second World War, author of the Universal Declaration of Human Rights in 1948, vice president of the Council of State, and later as the president of the European Court of Human Rights, awarded the Nobel Prize in 1968, along with the United Nations Human Rights Prize, founder and then president of the Federal Union of French Associations of Disabled Retired Veterans, their widows, orphans, and ascendants. His ashes rest at the Panthéon, Place des Grands Hommes, but his spirit and the spirit of our Rachel cottage lives on in the hearts and minds of our family and with those who continue to fight for justice and equality, because I remember he used to say, "There is something universal in every man."
Well, thank you, Caroline, for those very personal thoughts on a great figure. Our next speaker is Sir Geoffrey Bindman, KC. He suggested that I introduce him as a solicitor practicing in London since 1960 with a long-standing interest in civil liberties and human rights. And if I ever heard a greater understatement, I really don't know. Geoffrey established the firm that bears his name, of course, and which since 1974 has stood for providing accessible advice and representation at the highest standard. and in multiple areas of law, many of which draw on the enormous human rights expertise of Geoffrey and his colleagues, some of whom are here today. He served in many voluntary capacities over the years, including as chair of the British Institute of Human Rights, the Legal Action Group, and the Society of Labour Lawyers. He was knighted in 2007 for services to human rights, and in 2011, he was appointed Honorary Queen's Counsel. Mr. Geoffrey.
Thank you very much. Well, it's a great privilege to be invited to speak here, and I congratulate the Human Rights Lawyers Association on its 20th anniversary. It's a worthy organization and much needed at the present time. And my comments will mainly focus on my concern at the way in which our government and a lot of ill-informed public opinion in Britain is critical of the convention and of human rights in general. And of course, we only recently are seeing again revived the idea from government that they may seek to resign or retire or remove themselves or remove our country from the convention, which in my view would be outrageous and a disaster. And I'm sure that the Human Rights Lawyers Association will be in the forefront of opposing that possible outcome. The issue that concerns me most is an issue which concerns me a great deal is misinformation and misrepresentation of human rights as a kind of foreign imposition, which has been imposed on Britain by a lot of people who bear us ill will. And what I feel has been under-emphasized, and I would argue strongly for, is much greater emphasis on the fact that human rights and the Human Rights Convention internationalizing human rights is very much a product of British history, and it's something which those who purport to be people batting for Britain and putting Britain first have every reason to support, and this is why I feel that the present government and the campaign by, for example, Suella Braverman, and previously by Dominic Raab, who is no longer, I hope, in a position to impose his views on the rest of us any longer. This is what they have been presenting to the British people, as if somehow the Human Rights Convention is not something that Britain needs to be part of. And the corollary of retiring or removing ourselves from the ECHR, if that's achieved, which I sincerely hope it won't be, is that we would need to have our own Bill of Rights or our own form of set of principles which would be binding on our legal system. But I think that would mean that our Supreme Court and our court system would then be in the position of adjudicating on constitutional issues and to a much greater degree than they do at present. And if we look at the example of the United States, where, of course, the Constitution is interpreted by the Supreme Court, and the Supreme Court has the right to declare legislation unconstitutional, we're now seeing how the politicization of the court has led to the Constitution becoming a political instrument of the government in power. And well, not necessarily the government in power, but the government represented the power, the party most represented in the membership of the Supreme Court. And that seems to me a very serious danger and a warning that a Bill of Rights culture and a system in which we don't have the access to the European Court of Human Rights would be extremely dangerous and anti-democratic. So I really only wish to say that I feel very strongly that the campaign, which I think has to be continued and vigorously, to preserve membership of the Human Rights Convention and to support human rights generally in this country, has to be strengthened, fought vigorously, and the true, if you like, the pride that can be taken in the British contribution to human rights needs to be more emphasized. After all, it is the Conservative Party, which is members of whom are notable exception of my neighbor next door, who is pushing for this idea of leaving the Human Rights Convention. And they are the people who are stressing the idea, which is a completely false one, that the convention and international human rights are somehow not British and somehow an invasion of British sovereignty, when in fact that is absolutely untrue and the reverse is true. And we need to keep saying so loud and clear. Thank you very much.
Thank you very much, Geoffrey. Well, like Geoffrey, the Right Honourable Dominic Grieve, KC, requires no introduction. He was the Conservative MP for Beaconsfield for 22 years, from 1997 until 2019, when he fought and lost a seat as an independent MP. He was Shadow Home Secretary between 2008 and 9, Shadow Justice Secretary 9 to 10, and Attorney General, of course, of England and Wales between 2010 and 2014. From 2015 to 19, he was chair of the Intelligence and Security Committee of Parliament. I hope he won't mind me saying that he enjoyed a rare reputation for integrity and decency as a law officer. And of course, all his successors enjoyed the same rare reputation. This is the apolitical HRLA, and we have to be fair to everyone. Dominic, thank you very much.
Thank you very much. And it's a great pleasure to be here, a great pleasure to be celebrating the HRLA's anniversary, and also to be with Kingsley Dapley and to thank for the hospitality. Now, I wanted to cheer you up a bit, because there was a moment when I sat at the back of the room, particularly when Connor got going, and I thought, crikey, at the apocalypse now. And so I thought I would come back to the apocalypse a bit later, but I thought, let's try and get just a sense of perspective. We all know the reality. I know we talk about God's laws and things of that sort, but law is a man-made construct. Just so happens that all of us in this room, and for very good reasons, think that constructing some international law which defines and frames the way in which states deal with people who come within their power, because that's what we're talking about, is a really good thing. And actually, the United Kingdom has been doing this in different ways for a very long time. I do remember when I was Attorney General making an inquiry of the Foreign Office as to how many international treaties we were signed up to. And they got into the most terrible sort of tizzy about it, really. They said, we can't go back beyond 1834. So we actually miss out some quite interesting treaties, like, you know, the Treaty of Paris, when the United States first was set up. But leaving that to one side, back in 2013, they said, well, we've got 13,200 treaties to which we are signed up, which we consider to be active. From time to time, when I was Attorney General, I had to advise on ones which were thought to be obsolete and whether they could therefore be ignored. And of those, 800 included arbitral mechanisms for resolving differences of interpretation, which is actually exactly what the European Convention on Human Rights is all about. So, in fact, I think we are now signed up to over 14,000 international treaties. Of course, they vary from UN charters, the rights of the child, to sort of fishing access agreements between France and the United Kingdom about the Channel Islands. I mean, this is everything. But nevertheless, I suspect we are the greatest treaty-making power in world history. And it's pretty in our DNA. But equally, I think that we have to accept that because of this, it's always going to be a subject of political controversy. This isn't a bit of an add-on. This is actually fairly central to how the United Kingdom has gone about its business. And I have to say, speaking personally, I think we have been very successful in doing it, in trying to make the world a better place. And indeed, if you go away and sit my former Conservative colleagues, because they are former, not only because I'm no longer in the House, but I'm no longer a member of the party. They haven't invited me back at the moment, and perhaps I don't wish to be just at present. But if you sit them down in a room and you start asking questions about all the things that the Convention and indeed the Human Rights Act has done, and I'm not going to repeat them. We had a wonderful, all trotted out before us this afternoon. Most of them would say, oh, actually, that's rather good. Of course it is. And why was it achieved? Because it was a living instrument. Now, I know that's quite controversial too, but if it wasn't a living instrument, it would be a dead instrument and it would be doing absolutely useless. And we would be stuck in the realm of 1953 and nowhere else. It's always been difficult to get implementation and observance. I look back over my political career, some of it's before I got into politics, but, you know, that wonderful evening when Mrs. Thatcher told her whips to force through the abolition of corporal punishment, and then decided she herself would go and have supper with Nancy Reagan to avoid being present. But in fairness, she was a lawyer. She knew she had to implement it. So that's why it was done. Or, before we start slating my former party too much, look at the way Labour got themselves into the most immensely difficult issue over pre-charge detention and also detention without trial. Something which was a government which had only recently incorporated the ECHR in the HRA, showed that when it came to some difficult issues where national security was involved, they got really upset and angry at decisions which now, when we look back on them, 15 years, whatever it is, 20 years, back, a bit more, 25, suddenly realized they turned out to be absolutely right by the courts. The world didn't come to an end. And actually, we improved human rights in this country. And then I think of David Cameron, who clearly had a bee in his bonnet. I think that he suffered from being Michael Howard's spad at the time of Shahal, and the iron entered his soul. But he definitely had a sort of downer on the ECHR, irritation about the ECHR. And of course, he then got terribly worked up over prisoner voting. If you go and read his memoirs, he explains in great detail why I had to be sacked as a result of his view on prisoner voting. And yet, where did we go with that? It was resolved by an administrative change to the prison rules, effectively. done by David Liddington. And apart from a half hiccup from the Daily Mail, nobody has thought about it since. And of course, one of the consequences of that was that David started and initiated something which had already been rumbling for about 5, 6, 7 years when we were in opposition. We must scrap the Human Rights Act and replace it with the British Bill of Rights, which somehow gives us more wriggle room to ignore the ECHR when we feel the need to do so. Well, I'll simply make the point that we are now 9 years down the track, and we still have the Human Rights Act, and we are still adherent to the convention. And of course, in that time, much has happened. Some reforms have been carried out to the way the convention operates with the Brighton Declaration that I did with Ken Clarke after it kicked in afterwards. And of course, the court is a human construct, so it isn't perfect either. I sometimes think some of its decisions may be questionable, but then some decisions of our domestic courts can be questionable as well. So I think we need to just calm down a bit, that whilst it is quite true that we as lawyers who support the principles in the convention know that we have to argue this all the time, I'm afraid that's just our lot in life, because this argument is going to continue for a very long time to come. It is part of the processes of democracy. And I'm not even going to be too critical of my colleagues who get exercised or worked up about it, because they're representing what they see as their own interest groups and they think worry them. And therefore it is for us to explain why actually the ECHR and the Human Rights Act can help and facilitate sensible government, bring our partners who are important within a framework which works. Pick up what David Anderson was saying. Implementation of judgments is often very poor. It was very poor 10 years ago when I first looked at these figures. I remember then. He's updated us this evening. And yes, it's unfortunate. I think if you sign up to a treaty, you should jolly well implement the decisions. And actually, the United Kingdom's rather better than most countries at doing it. So we should take a bit of pride in that, despite all the criticisms that can be leveled at other things the government's doing. But we've got to accept this discussion will continue. Now, to move to the apocalypse, I do actually accept that Connor made a very important point, which is that we are living in a world where the level of disturbance to human existence is growing enormously. And I don't think we should underestimate the challenge that we are going to be facing, because whether it's climate change or population growth to levels which bluntly are not sustainable in some places, and the migration or emigration or immigration that accompanies it, are, I think, really serious challenges. But interestingly, they've got very little to, well, the ECHR and the HRA may have a lot to do with some aspects of how we approach it, but they are not the cause of this, and their disappearance would make absolutely no difference to the challenge and some of the ethical and moral issues which it poses for us as a society and as human beings. Now, that is a real challenge. And therefore, let's face it, we are going to be have some very busy times ahead. But we also have much to celebrate correctly. And I think a lot has been achieved. And it's easy to forget when one's looking at violence on one's television screens and the use of violence for whether they're legitimate or illegitimate ends, to sense that the world is a very bad place. Well, it isn't a good place, but actually it's significantly better to the world which existed 100 years ago in terms of the level of violence which is imposed on people. And I think we should always keep that in mind, and that is partly a result of all the effort that has been put into bringing about positive change by people like René Cassin and all those who were the creators of the ECHR and ultimately the HRA. So I think we should end this evening on a positive note about what we've achieved, and also perhaps a kinder note to those who haven't yet seen the light. Thank you very much.
Thank you very much, Tommy. I think we all appreciated that upbeat final contribution on the panel. we have time for questions, and I hope. Yes, well, I'm not sure the keynote speaker is allowed to ask questions, but by special dispensation. I think there's a mic just next to you, Robin.
I was actually just
Oh, I see. All right. We'll hear more from here in a moment. Any other questions? Yes, Marcus.
Hi, I'm Marcus Findlay. I'm a barrister at 15 MBS Chambers, and I'm a member of the executive committee of the HRLA. Just a quick question for Dominic. Could you make the best right-wing argument in favor of human rights so I can win arguments with my father-in-law?
Human rights are, the convention is in substantial part, as I suppose the exception to a right to a private and family life and privacy law, a derivation of common law principles and liberties that are anchored in the development of the history of England. You go and tell him that, and you tell him, take him off to read Sir John Fortescue's De Laudibus Legum Angliae of 1453, where he denounces the use of torture and says it's contrary to the common law. I mean, admittedly, kings carried on doing it for another 200 years, and arguably it's been done by the state on one or two occasions since then as well. But nevertheless, that's what he says in 1453. And he praises jury trial, and he praises the fact that the king cannot govern by mere will. So take him to that, and that may make him happier.
And tell him that Dominic Greaves said that. Yes.
Hi, I'm Konstantin Dixero. I'm a professor in human rights law at the University of Liverpool. Thank you very much. It was a very interesting panel. My question is, what can the European Court of Human Rights do to please the United Kingdom? I think there is almost no case law against the United Kingdom at the moment. There is very little the court is actually doing. Well, some odd Rwanda Rule 39 case comes around, but like the court cannot do anything to avoid it, to be honest with you. Is there anything else the court can do to be nice to the United Kingdom to earn some reciprocity in that respect? Thank you very much.
Yes. Well, I think the answer to that is no, because the reasons for the criticism of the court are essentially political. They're not based on fact. They're not based on what the court is doing. So I think it's a lost cause in one sense. But I think that the argument has to be, as Dominic was saying, and as I was trying to say earlier, that it is essentially a British, it is in line with British history, with British philosophy, British constitutional theory, and so on. So it's a very British thing, and if you're patriotic, you should support human rights and the convention.
The only other thing I would add is they should. Actually, I think she's probably been recently. They should be very welcoming to the current Attorney General as she goes over on visits, because I think you will find that actually at quite a few levels, even within the current UK government, there is perfectly clear understanding of the value of the ECHR and the Human Rights Act. And indeed, I detect that the Prime Minister, I think, understands this as well. What is so strange about our modern politics, but perhaps it's always been the same, is the extent to which politicians feel the need to pander to themes rather than challenging them when they're raised. And it's not a phenomenon which is unique to the Conservative government. Labour did exactly the same thing. And it is one of the real oddities, particularly because you go off and look at opinion polling,
which says, there's an opinion poll out today on this, which says that the public, when polled, keep on saying that they would like politicians to be straight with them. I mean, by overwhelming majorities, 78, and yet politicians seem to constantly believe that they can only survive and maintain government by not being straight. And it's a deeply ingrained phenomenon, and they surround themselves with all sorts of people who spin and interpret and massage truths rather than actually coming out. And I've always been fascinated by this because I keep on wondering when the day may come when there is some politician somewhere who says it as it is, and whether that is immediately the moment when they're consigned to electoral oblivion at the following election, or whether actually it might work.
Thank you very much. Adam Smith-Anthony from Omnia Strategy. We've heard from this panel and earlier how the ECHR is derived from English law, and of course the wonderful origins of the Universal Declaration of Human Rights. To what extent do you think the next few years, the development of international human rights law, will be marked by the engagement of other parts of the world in the substantive evolution of human rights law?
Polly, that's a difficult question to answer. I really don't know the answer to it. I'm sorry to say, but I think one in a way, it's incumbent on those countries like this country who have deep knowledge of human rights and human rights law to propagate the message and to educate other parts of the world. I think that's but beyond that, it's very much a question in particular countries, different parts of the world, what kind of educational system they have, what kind of population they have, and to what extent these issues can be communicated to the public in those countries.
I was just going to add, I do think that this is quite a challenge because on the face of it, we are seeing the rise of authoritarianism globally at the moment. And it appears to be quite attractive to some people. You only have to look at what's happening within the European sphere and in the United States to see that authoritarianism is seen as being a solution to problems. And of course, there is now in China a country which is a major authoritarian world power, which is trying to spread its influence. And indeed doing it with complete lack of scruple when it comes to any issues concerning human rights. The question is, will there be a kickback on that? I suspect the way human affairs works, I think there will. Because ultimately a yearning for security and freedom is very deeply ingrained in people. Clearly, they sometimes trade it for security and because they're frightened and are willing to do it. But on the whole, a desire for freedom reasserts itself, in which case they need a framework of protection. And so I think the opportunities will be there, but I also have to say I think the challenges are getting very big at the moment because they're now on quite a major scale, which probably wasn't envisaged when the Iron Curtain came down in 1990.